Hello, this is the 2024 Legislative Update for Law Enforcement. My name is Arnold Hahnemann, Deputy Executive Director of the Colorado District Attorney's Council, along with my colleague Brad Turner, Staff Attorney. We are going to discuss the bills that passed this past legislative session. A couple of housekeeping rules for you all here in person and for those that are watching this video online. You should have a corresponding CDAC booklet that goes along with this presentation, and a couple of things I just want to point out about the booklet as we go through. This presentation is a summary of the legislation that passed, as well as what is summarized in the booklet, but is still your obligation and responsibility to read the law and to be understanding of the full application of what has changed. We attempted to highlight the most salient points in these bullet points, but it's your obligation to still go back and take a look at the statute in terms of what the law fully covers. A couple of things that I want to point out about the booklet. We have 56 bills that are covered in this booklet, but we're only in this presentation going to cover about 36 of those that we think are the most relevant. A couple of these bills are primarily for law enforcement and others are for informational purposes. This booklet is prepared pretty quickly after the legislative session, so there are a couple of typos that we want you to be aware about, and I will identify those in just a moment. I do also want to point out a couple of things about this booklet. Starting on page 105, there is a list of the effective dates of when the bills go into effect. Different bills have different effective dates, so page 105 in this booklet lists all those effective dates by bill. And then on page 107, most importantly, there is a summary of about 12 or 13 bills of the actual bills that either create or amend a criminal offense. So for easy reference, page 107 will list those bills that identify those new crimes. And then lastly, on page 108 is a statutory index. This booklet will be helpful until we get the CRS booklets in October to be able to reference the statutory index on page 109 through page 115 or so. That's going to list all the statutes where there was an actual change in the legislation. If you can't remember, for example, if we talked about the theft statute or what have you, you can go to that index and see if there was, in fact, a statutory change. Now, with respect to just a couple of typos, one is minor, one is a little bit more substantive. On page 20, which is House Bill 1150, false slates of electors, there was a minor typo in the second bullet point, the black bullet point, the fifth white bullet point. It says subordination of forgery. There's actually no such crime. It should be subordination of perjury. So a slight typo on page 20, second bullet point, fifth sub-bullet point, subordination of forgery is in fact supposed to be subordination of perjury. And then on page 46, minor typo, the CBI investigation authority to investigate firearm crimes. The very last bullet point, there's 4 bullet points on that page. Bullet point 4, the statement says mandates CBI to comply with all body can. I don't know what a body can is, but I know what a body cam is, and so slight typo there, body cam instead of body can. Lastly, for those that are watching the video online and for those of you here in person, there will be a CLE code for today's presentation. We think it might be the same for the video online presentation, but just be aware that we'll give you that information as well for CLE credit. The first bill in this section is the pretrial, trial, and discovery section, covering House Bill 24-1225 and House Concurrent Resolution 1002, first-degree murder bail and jury selection statute. Our Constitution, as written, allows people to be eligible for bond or bail if they're being held, except in capital cases. However, in 2023, we had a Supreme Court case, People v. Smith, that interpreted a change in the law because in 2020, Colorado got rid of capital punishment. People v. Smith then came down and said, well, since we got rid of capital punishment, an individual who had been charged with first-degree murder would thus be eligible for bond. That was not a helpful ruling. We need to ensure that, in fact, people who are charged with first-degree murder are held without bail. And luckily, we have some of the attorneys that worked on that case here in the room to talk about it. But in order to remedy that case, we have to go back to the voters of Colorado and change the Constitution. And so that's the substance of House Concurrent Resolution 24-1002. In November of this year, it's going to be put forward to the voters as to whether we, in fact, should be allowed to hold somebody without bond if, in fact, we as the prosecutors can demonstrate and meet that standard that if proof evident and presumption is great, then, in fact, no bond would be allowed for that first-degree murder suspect. If, in fact, the voters do approve that and pass that, then we have to have a concurrent statutory change to align the constitutional change with the statute. And so House Bill 24-1225 will mirror, if in fact the resolution or the voters pass that, in December a statutory change will take place, thus affecting the change in the Constitution, thus we being able to hold individuals without bond on first-degree murder. In addition, House Bill 1225 addresses some other statutory provisions with respect to capital offenses, which now technically no longer exist because we got rid of the death penalty. So we clarify and assure that with respect to preemptory challenges for first-degree murder, if there is a single defendant, each side will indeed have 10 preemptory challenges. And if in fact there are more than one defendant in a case, each additional defendant will allow each side to have 3 additional preemptories, but not to exceed a total of 20 for each side. So we're aligning the statutory language with respect to challenges if, in fact, the voters pass the ballot measure and the law goes into effect. Now, we can't give you an exact date as to when that is supposed to happen, because if the ballot measure is passed, it indicates that the governor will certify that when the ballot is canvassed. That's a statutory language. We're not clearly sure what that means. It just has to happen within 30 days. And so the governor will typically do that sometime in December. Once that happens, then the statutory change will go into effect. So that's the substance of 1225 and 24-1002. The next bill is House Bill 24-1244, Minor Autopsy Report Release Requirements. This was a bill that came about to address one particular case, but the overall situation where autopsy records are considered public records, even those involving minors. There was a case that came out of the 4th Judicial District where members of the media were able to get access to the autopsy records involving a young woman that had been killed and reported some of the details or had the information and reported some of those details that were in the autopsy report. And that, of course, was concerning to the family as well as to the prosecutors. This bill will exempt an autopsy report involving a minor as being considered a public record. So there's an exception that is in the law that would say it will no longer be considered a public record. It will not be available to the public, and it will only be available upon request. There are certain exceptions, entities including the DA's offices, law enforcement, public health agencies, fatality review teams, and whatnot. They will be able to access those reports for the purposes of carrying out their function. But beyond those agencies, the average citizen and the public will not be able to access those records. Now, if an individual wants to get access to the records, they can file a petition with the court. Upon receiving that petition, the coroner can respond to that, but there would have to be a hearing held first with the district court. The district court would have a balancing hearing to determine whether, in fact, the release of those records would outweigh the privacy interests of the family members of the decedent. The court would have to make a finding and then determine whether, in fact, it's in the best interest of the public to indeed release that information. Without releasing the information, the coroner can release some information within 3 days upon receiving a request, some limited information. But if that individual is trying to get the full access and they're not one of the accepted entities, they can petition and there will be a hearing to address that issue. The next category is going to be crimes and sentencing. These are not necessarily all going to be relevant crimes that you're going to see day to day, but this is a section to at least put you on notice of the new crimes that were created as a result of bills that passed this session. The first one is House Bill 24-1074, aggravated cruelty to law enforcement animals, and we'll talk about what a law enforcement animal is. Right now, aggravated cruelty to animals is a Class 4 felony. That's not changing, but we're going to add a new theory of that crime to add that if a person knowingly kills or causes SBI that results in death to a law enforcement animal, that will qualify under the crime of aggravated cruelty to animals. We also have a current crime, cruelty to service animals, which is a Class 1 misdemeanor. But that crime refers to certified police working dog or police working horse. Those two categories of animals are being combined and renamed law enforcement animals. So there's no change to the crime, it's just a change in the naming of what we're calling a law enforcement animal, which covers the horses and the dogs. Law enforcement animals are treated by veterinarians when they get injured. If a veterinarian has to, in fact, euthanize that animal because the injuries are so severe, the law also immunizes that veterinarian from being prosecuted. There have been a couple of bills over the last couple of years dealing with dogs and horses, but when these bills get proposed, a number of other constituents come out and say, hey, we want to make sure that we're protected and we're not going to be harmed by this. And so there's a specific provision dealing just with the veterinarians. I'm not sure that anybody would charge them for doing their job, but if there's a clear immunization provision in the law. There is also a provision that allows an individual, if they are responding to what they believe to be the unlawful application of unreasonable or excessive force by a law enforcement animal, they can use it as an affirmative defense that they had to use force to prevent that dog or that horse from doing what they were doing. So it allows a defendant to have an affirmative defense to protect themselves or another if, in fact, that animal is injured or killed. We have a law that passed a couple of years ago with respect to law enforcement accountability, where officers have to hold each other accountable if they see another officer engaging in excessive use of force. That is also now going to apply to those officers that are in charge of a law enforcement animal. So if one officer sees another officer, let's say, for example, a canine officer who is using force with that canine, and that officer believes the other officer is applying that force inappropriately, they are now required to report that to the supervisor and also actually intervene to prevent the use of that unlawful use of force. So it's an expansion and an additional responsibility upon law enforcement to ensure that they are watching their colleagues and protecting individuals' rights. And it will also apply to those officers that have to use law enforcement animals as part of their day-to-day work. The next bill is House Bill 1135, offenses relating to operating a motor vehicle. This is going to address the issue with respect to individuals who are operating commercial vehicles without a CDL. There was a law change with the misdemeanor reform bill that happened a couple of years ago that reduced the penalty for CDL violations. Law enforcement said that particular reduction to a Class A infraction was too low of a reduction. And so this is going back and returning the CDL possession violation back up to a traffic misdemeanor 1. So it's undoing something that was done in the misdemeanor reform bill that happened a couple of years ago. It's also creating a new offense called unlawful direction to operate a commercial motor vehicle, which will be a traffic misdemeanor 1. This is a situation where an employer, an agent, or an officer is allowing someone to drive a commercial vehicle, and they know, or reasonably should know, that that person is over 21 and doesn't have a CDL in their possession or is licensed and obtained CDL qualifications. This came about as a result of some instances where there were individuals who were driving commercial vehicles. They were not licensed, and they ended up causing SBI or death to other individuals. That kind of situation clearly is not a Class A infraction. That should be at the misdemeanor level. Obviously, if there are more serious injuries, there are other charges that are available to be applied. The bill also directs a standing traffic committee that exists right now to look into 3 areas for further study. One of those is to look at DUI enforcement generally. Is there something we as a state should be doing differently with respect to DUI enforcement laws? To also look at the number and the types of incidences that are resulting in careless driving, resulting in death. Is that something that we should be changing in terms of the numbers and the level of crime? And then lastly, a pretty significant area is the insurance-related offenses, no proof of insurance and so forth. This committee is supposed to kind of look at generally what's happening across the state with respect to insurance offenses. And in all 3 of these areas, the Transportation Committee is supposed to come back and possibly make some recommendations for the next legislative session as to whether any areas of the law should be changed with respect to DUI, careless resulting in death, and driving without insurance offenses. The next bill we have is House Bill 1150, false slates of electors. This came about as a result of the 2020 presidential election and some very publicized Colorado case law with respect to what took place in the 2020 election and the conduct of those individuals who are considered U.S. presidential electors. This bill is clarifying what conduct is prohibited if an individual is actually a presidential elector or somebody who is trying to influence the behavior of a presidential elector. This will only have relevance every 4 years with respect to U.S. presidential cycle elections. It doesn't necessarily create new crimes, but it creates the application of 5 existing crimes to prohibited conduct concerning presidential electors. And those 5 crimes are listed there. If, in fact, someone who is an elector or someone who wants to influence an elector is engaged in prohibited conduct, it can fall under one of these 5 crimes that currently exist. So these crimes exist in Title 18, but there's a cross-reference in Title I in the Election Code that applies these 5 pre-existing crimes to election conduct behavior. If someone is convicted under the Title I offenses, they're not necessarily subject to jail time, but a maximum penalty of a $10,000 fine for each violation. Again, only applies to presidential elections. Next one is 1353. I'll let Brad talk about firearms.
So the legislature decided to regulate dealers, FFL dealers who are selling firearms. And the way they did this is a pretty standard regime or scheme, is they first require that everybody have a permit. And if the penalty is if you don't have a permit and you're selling firearms, you're dealing in firearms, you've committed a crime. In this case, the crime is an unclassified felony. It's up to a $250,000 fine, and dealing firearms without a state permit. So then what they do is, because they know that you have to have a state permit, it then regulates all kinds of things that these dealers can and cannot do. These regulations, these state level requirements go into effect on February 1st. And that include all kinds of ways. How do you get a permit? What can you do when you have a permit? Has on-site inspections, reporting requirements, training in firearm retail for firearm retailers and employees. And again, most of the violations are going to be violations of the permit. So it's going to be essentially administrative through the state licensing scheme, most of this stuff. But if they're dealing without a permit, that's when you have the unclassified felony. And by the way, this does include a new 48-hour reporting requirement. You have to report to law enforcement after discovery of a person who the dealer believes, knows, or should know purchased or attempted to purchase a firearm in violation of the law. That is not, again, that is not a crime. That is an administrative regulation on the licensed person. The next bill is 2465, Mobile Electronic Devices and Motor Vehicle Driving. So this is the newest version of our texting while driving statute. It has been revised yet again, and they are really trying to home in on what they're regulating here. I will tell you, this is going, the main takeaway is this bill, this statute is going to be hard to enforce. Because first, it's a Class A traffic infraction, and you probably are going to have other infractions when you were able to charge this. It's for using a mobile electronic device while operating a motor vehicle. And I think the actual language is in inverse of that. It's operating a motor vehicle while using a mobile electronic device. What does using mean? Look at the statute. There is a very clear definition in the statute. It sort of makes sense when you read it that means what using, that means it's commonly what people would refer to as if they're using the phone. For example, it's if they're looking at it, they're holding it, that kind of stuff. And is primarily for phones, but it's not just for phones. That's why it's mobile electronic devices. There's a list of what counts. You want to read that definition in this particular statute. While operating a motor vehicle, notice it doesn't say driving. That's a significant difference, and I think the distinction there is about driving sort of implies somebody is moving forward. This can control if someone is just sitting stationary in their car, say at a stoplight or something. Key part law enforcement officer must see the person using the device in a manner that is careless in order to cite them for this. So in every circumstance in which you can charge this, you can also just charge them with careless driving. What is the charge for a careless driving? Does anybody remember?
Class 2 misdemeanor traffic offense.
Is that right, or is it class 1?
Class 2.
Class 2? Class 2 misdemeanor traffic offense. This is a class A traffic infraction. Okay? So if you're going to charge careless driving, you're already charging a higher charge than this. Careless driving does not require the person to actually see the person operating it in a careless or imprudent manner, although if you have that, you can probably charge both. Then there's this real special provision that says they cannot be convicted if they produce proof of a purchase of a hands-free accessory, and that's defined in the statute as well, and they affirm under penalty of perjury, they haven't been charged previously. The clerk of courts is then tasked with dismissing this, not you. You charge, clerk of courts dismisses if this is met. If this does cause SBI or death, I believe it is a class 1 traffic misdemeanor. I didn't put that in here, but I think it's a class 1 traffic misdemeanor. Does not apply to CDL licensed individuals operating commercial vehicles. That's a big exception here. And you'll see a public awareness campaign starting on October 1st of 2024. The next bill is SB 24-108. This is the Prohibit Unauthorized Use of Public Safety Radio. I'll tell you, this bill is sparse. It does not include a lot of information about why this was created, what the problem here was, but it makes it a class 2 traffic misdemeanor to, quote, knowingly affiliate with a public safety radio network without authorization from the network's authorizing entity. The kind of stuff we're talking about here is police radio. It says a public safety communication system that facilitates communication between public safety agencies and is operated by the Department of Public Safety or local government. Includes radio frequency, radio channel, radio talk group that is used by a public safety agency. What does it mean to affiliate? Basically, you're on the network and you're transmitting information or receiving information. It does not include passive listening devices. When are you going to apply this? Who's going to charge this? I don't know, but you're likely to see fact patterns when someone is they're not a police officer and they're somehow interacting with these public safety radio networks. That's your likely fact pattern there. Next bill is SB 24-189. This is gender-related bias-motivated crimes. There are two sets of crimes here. There's the bias-motivated crimes, and then there's the bias-motivated harassment statutes. Those are the two sections you see there in bullet point 2. There's a couple of changes here. Originally in these statutes, transgender identity or transgender status was located under the sexual orientation definition. Gender identity is not about sexual orientation. They're different things. So the legislature this year took transgender status, gender identity out of the definition of sexual orientation and made it its own thing. So now if you look at the second bullet point, in this long list of protected classes, you see race, color, religion, ancestry, so on and so forth. After sexual orientation, you're now going to see or transgender identity. And transgender identity is about gender identity and expression. And then in terms of sexual orientation, they broadened the definition of sexual orientation to include emotional attraction. The reason why is because there are individuals who do not identify as having sexual attraction. Instead, they have emotional attraction. We're not talking about your average emotional attraction, right? You're not talking about, hey, my best friend, I really love them. That's my emotional attraction. That's not what we're talking about. We're talking about individuals who look like, essentially, they have a sexual attraction, they're in a relationship with someone, but they do not identify as someone who has a sexual attraction to someone. That's what you're looking for in those kinds of cases.
We're going to move on to victims and witnesses. The first bill in this section is victim programs in the new 23rd JD. If you didn't already know, we are creating a brand new judicial district as of January of 2025. This happened a couple of years ago. The legislature passed the legislation to do that. But there were some things that they missed in the creation of that new judicial district. It's pretty significant piece, an amount of work to do. And one of those areas that they forgot to address in that law a couple of years ago is what's happening with our Victims' Compensation Board and VAIL boards. 241013 actually creates those boards and says they are allowed to exist in the 23rd JD. And given that those boards are responsible for funding victim services, they have to be topped up and be ready to go in January of 2025. And so the bill actually creates those boards ahead of time, effective a couple of months before, i.e. November of 2024, to go ahead and to start functioning and for funding to be attributed to those particular funds. The 18th Judicial District, since it's now going to be broken up, they are responsible for managing those boards and have been moving some money over to the funds that will then be available for the 23rd when it comes online as of January 7th. In addition, both of these boards are funded in part by the Marijuana Cash Tax Fund. However, when they created the 23rd Judicial District a couple of years ago, they forgot to think about how are we going to fund these boards, and so they have to amend the marijuana statute as well to ensure that money is being transferred. So there's a couple of cleanup things basically for you all to know. And then lastly, the date has an impact. When they created the 23rd Judicial District to take effect in January of 2025, the date was January 7th. However, prosecutors, the new elected DA doesn't take office until January 14th. And so the problem is you were going to have an entire judicial district functioning without a DA for an entire week. That created significant problems. So another bill was passed this session, House Bill 1455, that says the 23rd Judicial District goes live on January 14th, when in fact there's a DA to work in the DA's office and run the office. Throughout this legislative process, CDAC, as you may or may not know, attempts to develop a couple of bills by annual conference every year, which happens in September, of 3 or 4 bills that we as the prosecution community thinks is important to spearhead and advocate during the legislative session. House Bill 1072 was one of those bills that CDAC and the prosecution community was behind moving forward, and that's the protection of victims of sexual offenses. One of the issues in prosecuting these types of cases is when the defense seeks to cross-examine and to go after a victim and challenge them on their consent to the alleged assault based in part on the clothing that they may have been wearing. And so this is going to prevent that type of evidence and cross-examination from happening, and to make it very clear that just because a victim or a witness might have been wearing a certain type of clothing, that is not indicative of consent. You can introduce the fact that the victim was in fact wearing clothing for some other purpose other than consent, for example, for DNA, the state of the item, changing of clothing during the assault, but it cannot be used to infer or to allege that that was an indication of consent. It also enhances the burden of proof on the moving party to include a 403 type analysis in statute and requires the judge to indeed consider, quote, unfair invasion of the victim's witness privacy before introducing that particular evidence into trial. So that would be, and in fact, a pretrial motion that would be litigated, and for the court to indeed do that analysis and make that finding in a pretrial motion. It also removes the presumption of admissibility of evidence of a victim's sexual history with the defendant and requires motions in those scenarios as well. Again, we're going to make it very clear that there isn't a presumption of admissibility, but that there would be a pretrial motion for the court to consider whether that evidence should indeed be admissible. And one of the last major provisions is to define what is false reporting and to make it very clear that just because a victim may have reported something to law enforcement and law enforcement didn't open up a formal investigation, or that a district attorney's office did not proceed with charges in that prior reported incident, that it didn't happen. And so it prevents a defense attorney from arguing that the victim has a history of false reporting on multiple occasions because nothing was done with that report. Just because there was no action taken on the report doesn't mean it's false. And so we're clarifying in the statute what a false reporting is. and that includes at least one prior incident of false reporting of unlawful sexual behavior that is demonstrably false or false in fact, and that has to be established by a preponderance of the evidence standard. So that's an evidentiary hurdle that would have to be made to allege that in fact the report is indeed false if there's some other evidence to demonstrate that it did not happen. So again, this is an effort to protect victims in the course of trial to, again, not be cross-examined on areas that are really not relevant to sexual assault, or relevant, rather, to consent regarding the sexual assault. The next bill we're going to talk about is House Bill 241122, Protection Order for Victims of Crimes. This is a broad-based bill to increase the protections for when a victim is applying for a civil temporary protection order. There's a catch-all provision in the protection order petition process that says if a victim believes they are in imminent danger of harm, that would be a basis for applying for a temporary protective order. That is being replaced with a broader phrase and removing imminent danger as the standard and indicating that if a victim or a person believes they are at risk or threat of physical harm or threat of psychological or emotional harm, that would be the basis of applying rather than the more strict imminent danger standard. With respect to sexual violence cases, it does not require proof that there is going to be a likelihood of acts that will be continuing. So it removes that higher standard of likelihood of the acts continuing with respect to sexual violence cases, given the nature of those type of offenses. We had a U.S. Supreme Court case recently ruled on, United States versus Rahimi, that confirmed that courts, in fact, can put restrictions on gun ownership in domestic violence cases. That's not going to change given that Supreme Court finding. And so it does ensure that, again, if a person is coming in for a protective order, that the court still has the authority to require the relinquishment of that firearm with a case that has a domestic violence tag associated with it, or in cases of temporary protective orders. With respect to permanent protective orders, the change also allows those to be granted without additional testimony or evidence from the petitioner, and will also grant the petitioner a default permanent protection order if the respondent failed to appear and there's proof that the respondent was properly served. So again, it's confirming that in the case of failure to appear, there can be the issuance of a default PPO. If the court denies an applicant the provision of a temporary protective order, it does not require that there be service on the respondent, and that's primarily to ensure that the victim safety is taken into consideration. No further requirement to serve the respondent with that denial of the protective order. And then lastly, cell phone providers can be ordered to separate accounts of an applicant for a temporary protective order in a domestic violence, sex assault, or stalking case. Again, this is allowing more protections for that victim or petitioner. If in fact that temporary protective order is granted, cell phone providers can be required to separate the accounts from the offender. Senate Bill 120 is also another broad-based bill to update the Crime Victim Compensation Act. Division of Criminal Justice had been working over the last year or so, working with different entities and directors to see what changes to the Crime Victim Compensation Act needed to be changed. After some consideration, the bill was run, the bill passed, and it does a couple of things. It now includes victims of motor vehicle theft to apply for CVC funding. That is now considered an eligible criminal offense. The term replacement service loss is added to the statute, and that's defined in statute. It's a broad-based term to include some additional items for which a victim can apply for funding. There was a requirement that an individual had to report within 72 hours, and that's sometimes not enough time for a victim to consider and make application for funding. So that 72-hour reporting requirement is removed. And then in addition, as evidence of a report, which is required, you have to have a police report in order to submit that to the Crime Victim Comp Board to apply for funding. A forensic nurse examination report would be sufficient. Sometimes an individual may not be willing to report directly to law enforcement right away, but they've gone in for a SANE exam. That SANE exam can be the evidence to then indeed apply for victim comp. There was also a one-year statute of limitations that after a year, an individual would not be able to apply for CVC funding. That one-year SOL has been removed. There's further expansions for the type of aid that someone could seek reimbursement or assistance, traveling to court for VRA cases, except if a victim has been subpoenaed or a witness has been subpoenaed and they're required to appear under those purposes. They can seek reimbursement for VRA-related cases, travel services, if they had to get a caretaker or they needed to move, if a vehicle has been towed or impounded and there's a cost related to that, or, for example, if an individual has to get medical or prosthetic devices, that will also be an eligible expense that they can seek reimbursement. There was an approval process that the board had to go through, and there was a limit in terms of emergency funding. I think the limit used to be $2,000. That $2,000 has now been removed, and the CVC boards will have further discretion with respect to emergency approvals. In terms of increases ability to fund staffing, DA's offices get a percentage. Right now, the percentage is 12% in terms of the amount of money that is paid to DA's offices to assist with staffing up those boards. That is increasing to 22.5%, so DA's offices will now have a little bit more funding in which to hire folks. And then lastly, individuals who are participating in diversion programs, as part of their fees, as part of that deferred case, they have to pay fees. Now that will also then help top up the CVC funding. So it's another source of funding for crime victim compensation. So we've got a broad-based bill, but important for your victim comp administrators to be aware of.
The next section is about peace officers and post-training. The first bill is HB 24-1093. This one is fairly straightforward. It simply says that the post board may now grant a person a provisional certificate as a peace officer if the person was a peace officer in the armed forces. The next bill, HB 24-1372, is called Regulating the Law Enforcement Use of Prone Restraint. Prone restraint, for those of you who aren't aware, prone restraint is essentially when a suspect, defendant, is put on their chest, on the front of their chest. So they're putting their body weight on their chest. This bill was introduced because there had been a number of occasions in which prone restraint had injured or even killed individuals. Now, the original versions of this bill attempted to say that prone restraint could only be used when deadly force was authorized. The problem with that, of course, is that if deadly force is authorized, that means an officer legally is entitled to use deadly force. Prone restraint is actually, by most police officers, considered far less than the use of deadly force. In fact, it's considered to be a very safe, for the most part, safe use of force, safer for the defendant, and safer for the officer. But so ultimately, equating the use of deadly force with prone restraint was removed, and this bill came out of it. This bill requires law enforcement agencies to establish policies, their own policies, surrounding the use of prone restraint. It does not require them to define or regulate when prone restraint is used. It does require them to do other things. There's a list, things like when do you have to call EMS? How soon after the use of prone restraint do you have to pull them up into a recovery position? How soon after the use of prone restraint do you have to call EMS? Those are the kinds of regulations that these policies are required to actually address. It's voluntary as to whether the agencies wish to define, regulate, limit, in addition, the actual use of prone restraint itself. These have to be created by July 2025, these policies. They have to publish them, they have to train law enforcement on them, and they have to review the policies at least once every 5 years. And there are consequences if they don't. It also requires Post to make its prone restraint training available to all law enforcement across the state. The next bill, HB 2403, this is CBI's authority to investigate firearm crimes. CBI, under this bill, is now a police force. They have original jurisdiction to investigate any crime under 1812. And if you look at 1812, you will see that any one of those parts includes lots of different crimes. Further, it's not just the authority to originally investigate those crimes, it's also the authority to investigate crimes that they find out happened while they're investigating those firearms offenses. There's a restriction. It's not clear what this restriction means, but it says they cannot pursue any other criminal activity encountered during the firearms investigation, quote, and this is really key language, without consent from or in collaboration with the local law enforcement agency. So if the local law enforcement agency does not consent, maybe CBI is still in collaboration with that. Maybe it doesn't require formal consent, something like that. So what you're going to find is this bill originated out of InstaChecks, and the controversy that some viewed about InstaChecks not being properly investigated, people purchasing firearms illegally, and those kinds of things not being properly investigated. There were some people who believe that these crimes are not being enforced by either sheriffs or DAs. And this bill is essentially, one of the animating principles behind it was to ensure that these kinds of things are investigated. Some sheriffs also were asking for CBI to help them investigate, because some of these sheriffs, especially in rural counties, for example, maybe don't have the resources to investigate. Because CBI is now effectively a frontline police force in the state with jurisdiction over any firearms offense, and again, it's shared jurisdiction, local law enforcement can still investigate these crimes, but they are now, CBI is now required to comply with body cam requirements as a result.
The next section we're going to cover is motor vehicle and traffic. The first bill is House Bill 241055, Child Passenger Safety and Education. This bill came about from advocates who wanted to address the child passenger safety requirements and what is required with respect to a child who is supposed to be restrained in a child restraint system. So the first change, an important change, is to amend the age requirement with respect to at what age a child needs to wear a child safety restraint seatbelt, basically a seatbelt. It amends the language from under 8 years of age to under 9 years of age. At that age, an individual needs to use a child restraint system or safety belt for children transported in a motor vehicle, generally, or by a child care center. The next change, substantive change, and that's described in the booklet with respect to weight limit and age, it raises the thresholds with respect to age and weight limits for children to be properly restrained in either a rear-facing or front-facing car seat. But if there is a rear seat available in the vehicle, then they are supposed to use the rear seat with respect to that child restraint system or car seat. These changes will go into effect on January 1st, 2025. The age thresholds changes from age 2 years to 4 years. It goes up. And the weight threshold moves from 20 pounds to 40 pounds. So there are some details there. Take a look at that in the booklet and in the law, but just be aware that those thresholds are changing. The next bill is House Bill 241161, Motor Vehicle Access with Individuals with Disabilities. There are legislators who advocate on behalf of individuals with disabilities, and a couple of provisions in 1161. The first provision is to require that a person shall not park a vehicle or block reasonable access to curbs, ramps, passenger loading zones, access aisles, or accessible routes that are clearly identified unless a person is actively loading or unloading a person with a disability. So even if an individual is unloading their vehicle or there's a person who is exiting the vehicle that has a disability, those individuals are also not allowed to block access to curbs, ramps, passenger loading vehicle areas, or what have you. So it applies to everyone not to block those access routes. If a business or an entity obstructs access to a reserved parking space, they can be subject to a monetary penalty. And then lastly, importantly for law enforcement to know, if a peace officer or an agency receives a complaint about an individual who is violating one of these reserved parking restrictions, the law says that that shall be investigated by the law enforcement entity or to notify state or local agencies that have jurisdiction over that particular area. And the language of the law says that an agency must investigate within a reasonable time. So this is putting you on notice that you need to take these reported violations seriously, investigate them, or pass them on to another agency to investigate appropriately. I'll now pass it on to Brad for some additional laws under this particular category.
The next bill is SB 24079. This one is entitled Motorcycle Lane Filtering and Passing. Colorado had a kind of an anti-lane splitting statute. The position was that you can't ride your motorcycle between cars and between the cars and the lanes. This changed this year, and the reason why it changed is because I believe that motorcyclists believe it was safer for them to be able to lane split. At least those were the arguments at the legislature. You are now able to lane split legally if you can do the 5 things listed here. First, the vehicle that is being passed has to be stopped. It has to be stationary. Now, if it might be on the highway, and the highway might be very busy, the vehicle might be going, starting, going, stopping. As long as it's stationary when the motorcycle passes it, that's good. The vehicles in the adjacent lanes have to be stopped. So you're looking for a situation in which there's a line of cars and they're both stationary, and then the motorcycle is driving between them. Motorcycle has to have lanes wide enough to safely pass. It has to be driving less than or 15 miles per hour or less. And the conditions have to permit this being done safely. So let's say it's snowy or something. That would be a reason why you're not be able to do this. You cannot, the motorcycle cannot overtake or pass once the vehicles around them start moving again. So I'm sure you've all seen this on the highway. Motorcycles passing you by while your car's moving, while the car next to you is moving. They're passing by on the far right shoulder. They're passing by in all kinds of circumstances. Almost all of that's illegal at this point. So even though it's supposedly this is safer, these are the conditions under which you are allowed to legally do it. And this other stuff is all going to be essentially illegal. You cannot pass also in the farthest right-hand lane if the highway is not limited access. I don't fully know what that means, but I'm told that what it means, a limited access would be, say, a major highway where there's only a few on-ramps, as opposed to a highway in a rural area where there's driveways, there's all kinds of things coming onto the highway. You can see why it would be safer to do this kind of thing if there is limited access. And you cannot split lanes in a lane of traffic moving in the opposite direction. Do not drive into head-on traffic if you're a motorcycle. That is probably a bad idea for you and everybody else. The next bill is SB 24100. This is the Commercial Vehicle Highway Safety Measures. This one is of probably marginal importance to DAs, but what it does is it does increase speeding penalties for commercial vehicle drivers in certain enforcement zones. There are 2. Glenwood Canyon and Interstate 70 eastbound between these 2 mileposts, and westbound between those 2 mileposts. That's that. Just increased speeding penalties. DAs probably don't have to worry too much about that. However, there is a new crime here. It's a Class A traffic infraction for the driver of a commercial vehicle to enter, unless required or authorized by law, the furthest left-hand lane between the mileposts on this list. You will see. You're going to know this, you're going to get to know this, and you're going to see this kind of stuff coming in from police officers. Just make sure it's within these mileposts and it's in these areas when you charge the crime. And then it also creates restricted areas on certain highways during certain times of the year. Think winter weather on certain highways. It's going to require that commercial trucks, basically big commercial trucks, these are things with declared gross weight of 16,000 pounds or more, they have to they have to equip certain equipment on these areas. So I don't know what all that would require, but I'm thinking chains, things like that, to make sure that they're safe when they're going over these mountain passes in these areas. I don't know if these are all mountain passes. SB 24182 is the Immigrant Identification Document Issuance Bill. This bill allows individuals unlawfully present in the United States to be issued a driver's license or identification card if they can present certain identifying information. This would be most applicable in county court, where you see individuals who say they cannot get a driver's license because they are undocumented. According to the law, you can do that now. SB 24195 was titled Protect Vulnerable Road Users. This is mostly about what's called the AVIS system, which is the Automatic Vehicle Identification System. Law enforcement, I assume law enforcement already knows about this. This is the kind of technology that's used to detect violations, traffic violations. It's the cameras and so on and so forth that automatically detect these things. This bill allows CDOT, Colorado Department of Transportation, and the CSP, Colorado State Patrol, to use this system to start automatically tracking, identifying traffic violations on any portion of a state highway. That appears to be one of the newer parts, something new that was not previously permitted. It does require localities moving forward to notify and coordinate their use of this system with CDOT and CSP. It requires that certain signs be posted when using this. So you have to say, hey, I don't know exactly what the signs are, but something like, hey, you're about to be recorded by a system that could potentially result in a fine or something like that. It does give Colorado Department of Transportation power to promulgate rules governing the use of these systems starting in January 1st, 2025. That's new. We don't know what kind of rules might come out of this. This bill does not apply to toll roads. Those are essentially private roads separate from this. And it's interesting, it does say that specifically that car rental companies are the ones that are liable for violations of traffic offenses observed from this system, but it allows, in turn, those car rental companies to seek reimbursement from the customer who caused the violation. So you're supposed to ticket the car rental agency, and then the car rental agency recoups those funds from the person who actually violated the law. We're now going to get into juvenile stuff. And HB 241216, Supports for Youth in the Juvenile Justice System. This is a bill that basically does, it basically encourages, it doesn't require anything, judges to consider when determining bond and bond conditions and when deciding when to commit a juvenile to Department of Youth Services, so juvenile prison basically. The judge is now encouraged to consider that juvenile's progress in their education. And the reason why is because I guess it's possible that sometimes a juvenile's right about ready to graduate, or they're about ready to finish some credits that they would need, and the judge is encouraged to say, hey, okay, maybe if we just wait a week, this person can get some credits that they need, some education that they need, and then we can commit them, or we can detain them, or whatever. One thing it does do that applies beyond that is the third bullet point here. This grants juveniles in delinquency, not all minors, but juveniles in delinquency, a right to privacy at school related to diversion, probation, or questioning about a crime. So this does not apply to juveniles who are not in delinquency. This applies only to juvenile delinquents. If they're on probation, if they're on diversion, and even if an officer goes there to ask them questions, goes to a school to ask them questions about something that has nothing to do with their present case. Let's say maybe they are a witness to a crime, but they're a juvenile delinquent. The officers who go into schools are going to be required to separate that juvenile out so that they're not embarrassed in front of their peers by a probation officer or a police officer or a diversion officer, although I've never heard of a diversion officer going to school. They are now required to separate that kid out, make sure that the peers are not seeing this interaction happen. It's really designed to reduce the embarrassment of juveniles being on diversion and probation.
Okay, the next section that we're going to talk about are drugs. We have a couple of bills in this section. The first one is Substance Use Disorders Harm Reductions, House Bill 1037. Brad mentioned when he was talking about the juvenile rights bill that many times juveniles have been granted a prescription for an opioid antagonist. This is going to grant immunity and civil protection from individuals who not only administer the opioid antagonist, which is current law, but anybody who distributes the antagonist to those individuals. So we're expanding the scope of people who might be involved in the distribution or administration of an antagonist, and broadening the civil and criminal immunity for those individuals as well. If a peace officer comes upon an individual that may have been suffering an overdose and in their possession or in their presence is an opioid antagonist, there's a typo in the book. We left out the word antagonist, but to be clear, if in fact a person has an antagonist on their person or near them, that cannot be the sole basis for a police officer to use that as probable cause to then conduct a warrantless search of the individual. So substantively, that typo in the book is important. Clearly, if they've got opioids and other drugs, that could be indicative of reasonable suspicion of some other crime. But if in fact it's an antagonist, the antagonist alone cannot be the basis for establishing PC. If a law enforcement officer comes in contact with an individual and they have drug paraphernalia on their person, i.e. a syringe or something that they may have received from a needle exchange program, that cannot be used as a basis for charging the crime of possession of drug paraphernalia. Now, in terms of the enforcement and application of this, clearly the officer and the individual are going to have a conversation about where they got the syringe. I don't know if that's really going to happen. As we did this presentation recently, we were told that harm reduction centers are, for example, giving people cards and issuing cards that they could then show to the law enforcement officer to say, hey, this paraphernalia that I have on my person, I obtained from a harm reduction center. It's going to depend on the type of paraphernalia that they have in their possession. We're talking about syringes and not all categories of drug paraphernalia. The example that one jurisdiction mentioned was they've got individuals coming in who have been charged with possession of drug paraphernalia, i.e. a meth pipe, and showing this card that they received from a harm reduction center saying you can't charge me with the crime. Well, the argument being a meth pipe is not considered drug paraphernalia. That is actually something different, and it's not going to be a basis to then avoid a possession of drug paraphernalia offense. Lastly, medical professionals have a mandatory reporting requirement to report to law enforcement certain injuries that they believe may have resulted from a criminal act. The bill is now going to exclude if a physician or medical provider observes an injury that's related to the possession of drugs or drug paraphernalia, and that's all, and that's what the physician observes, they are not then required to mandatorily report that to law enforcement. Again, there are different perspectives and views about harm reduction. A number of bills didn't pass. This one did. So this is basically what 1037 is providing. The next bill is House Bill 1081 and involves the regulation of a substance that is now frequently being available to individuals on the internet. Sodium nitrite is an easily accessible substance that easily facilitates suicide or someone attempting to commit suicide. There have been cases around the country where individuals are peddling this substance, and the idea is to regulate the control and distribution and sale of sodium nitrite. It's just too easily used in facilitating suicides. So what the bill does is it prohibits the sale or transfer of a product that has a concentration of more than 10% in the substance, unless someone is actually in the business of selling this and they qualify as a commercial business, and that term is defined in statute. So the regulations are controlling a number of things. One, the sale or transfer of the substance. Two, the labeling of the substance. And if in Colorado someone is actually in the business of distributing, that there has to be records as to who they sold it to and some other requirements. And again, this is primarily to allow law enforcement to go and investigate. This is of importance because there are suicides that may have been facilitated by the distribution of this drug, and the idea is to limit the ease of this being available in the market. It does not necessarily, well, 1081 creates a civil penalty. So if someone does, in fact, violate the provisions of the statute, which go into effect in July, it's a $10,000 fine for the first violation and up to $1 million for any second or subsequent violation, and those are civil penalties that are available. the Attorney General's office has the authority to, in fact, investigate. They've got a deceptive trade practice authority that would be allowed to be enforced if, in fact, any aggrieved individual is harmed by that. And that would include potentially family members of someone who died by the death of the ingestion of this substance. This next bill we're going to talk about is Senate Bill 47, Prevention of Substance Use Disorders. Overdoses are clearly a problem across the country, and here in Colorado, the legislature wants to do what it can to address those issues, and that may include the Department of Public Health or a local public health agency issuing an order establishing a multidisciplinary team to investigate the incidence of overdose deaths, and in particular, a specific case of an overdose fatality. The bill is going to create this multidisciplinary team, which will include potentially a district attorney, public health officials, law enforcement, and some others to investigate those cases. And in order to do their work, they have to request information about that overdose death or that fatality, including providing or getting records from law enforcement and district attorneys to review the details of that death. That information is going to be privileged and confidential. So as DAs or law enforcement entities or public health entities provide their records to the multi-agency team, that team has to, in fact, keep that information confidential. All the team members have to sign a affidavit of confidentiality. Those members of that team can't not then be subsequently called into court, and they're not subject to subpoena to testify in any civil or criminal case. And they are immune from liability as well for the work that they're doing as part of that team. The records remain confidential. The work of that team is not subject to discovery or subject to subpoena. Now, the creation of the team in the first place is probably going to happen by the director of the public health agency in that particular jurisdiction. And so it has to be created, in fact, by a public health order to create the local team. But there are some guardrails that are put around the creation of the team. And again, anything that they're doing, they make it very clear that the work of the team is not considered public records and not subject to KORA. Lastly, because the teams may in fact include a member of law enforcement, and law enforcement may be asked to turn over some of their investigative records, if that member of the law, that representative of the law enforcement team, or the law enforcement agency is part of the team and they learn information about a particular overdose death, they can't then use that information that is gained in the MDT work and go and use that for further investigation. They can't use it for following up on welfare checks, warrant checks, other investigations. By participating in that multidisciplinary team, they have to keep that information confidential. Anything they learn in that cannot then be used for the basis of further investigation. Guns.
Next bill is HB 241174. This is the Concealed Carry Permit and Training Bill. It was designed to increase or create new requirements for those who obtain or renew their concealed carry permits, and for those who are training those individuals who are obtaining or renewing their concealed carry permit. There's now new live fire requirements and accuracy requirements and written exam testing. Those are now required for obtaining or renewing a concealed carry permit. It also issues these instructor qualifications and guidelines. And in fact, it makes it a deceptive trade practice under Colorado's consumer protection statutes if a person represents that they are a certified instructor when in fact they have not passed the certification for that. If a person is denied the ability to be a certified instructor, that's actually appealable and something that somebody could potentially overturn. So really this bill is just creating some additional requirements on those who are carrying concealed weapons and those who are training individuals to carry concealed weapons. This legislative session, a bill called Secure Firearms Storage in a Vehicle passed. It's HB 241348. This makes it a civil infraction, which means you're probably not going to be dealing with it, of unlawful storage of firearm in a vehicle. It does require a person to essentially secure their firearms when they're leaving their firearms in a vehicle and then they're leaving that vehicle unattended. It does distinguish between handguns and firearms, and it basically says there's some scenarios which, what counts as securing your handgun versus what counts as securing your rifle, for example, might be two different things. And I don't need to go through all the details because you're not going to spend a lot of time on this because it's an infraction. But just know that you have to do it. You have to lock it up. You have to keep it out of sight as well. The also interesting thing about this statute is a person who violates this statute, they leave their Glock sitting on the passenger seat of their motor vehicle, and they walk away, and a juvenile comes up to the car. This is a lot of times how juveniles are obtaining. I see that the juvie person in the room is nodding their head. This is a lot of times how juveniles are obtaining firearms. Sometimes they do this as groups, and they just go around and try cars and try to get firearms. Let's say the person leaves their firearm in the motor vehicle, it's stolen. If they then report, the owner of the firearm reports that as being stolen, there's a statute that requires firearms to be reported when they're stolen. Then that person, that owner, is immune from prosecution from this. In other words, there's encouragement to report the firearm being stolen, as opposed to if you left it in your car and you didn't comply with the law, you might have discouragement to basically report yourself for having violated the law. But here you're immunized if you go ahead and you report it. There are exceptions in this case. Peace officers, military folks, hunting license personnel, storing antiques. So, an 1812 musket is not going to be subject to this. Farm and ranch operations. Sometimes people are putting, guns on the back of their truck because they got to make sure that their livestock are protected. Those are examples of exemptions from this. So, civil infraction, it's important that you know it exists and that this is a new regulation, but you will not likely be involved in this. SB 24131, this is prohibiting carrying of firearms in sensitive spaces. A lot of members of law enforcement, DA community themselves carry firearms, but since you're a prosecutor, you will be asked to enforce this statute. This is a new crime. It creates the crime of unlawful carrying of a firearm in a government building. See how it says building? Get building out of your mind, because if you look at the statute, it's not just buildings. I've copied and pasted in the actual charge codes that we have. CDAC creates charge codes for every new crime that exists. That's why when you go into action and you search for a crime, it pops up. It's because we've gone through and we've created it. We have a pleading committee where we have individuals who help us do that. And this is the actual text you're going to see. You'll see that it says, unlawfully knowingly carried a firearm, whether loaded or not loaded, it doesn't matter, on the property of, within the building of, in the adjacent parking areas of the property or building of. So if there's a meeting in a government building and somebody's carrying a gun on the outside, whether loaded or unloaded, if that's unlawful, it's a crime. And then you see when you're charging this, you have to pick the location, and the location has to be one of these places. I'm not going to read all of these. You can read that yourself in the statute, but just know it's not always in buildings. But it is where government operations are taking place. So maybe a committee meeting is taking place in an area that is not normal for that committee. If the committee meeting is taking place there and a person is unlawfully carrying a firearm there, then that's a problem. There are exceptions, law enforcement, obviously, defense counsel, court personnel. Those are the exceptions. It is a class 1 misdemeanor. This bill did some other things too, interestingly enough. It actually reduced the crime unlawful carrying of a weapon on school grounds. The firearm subsection, that's now a class 1 misdemeanor. The deadly weapon subsection, which would say include knives, is still a felony. It's still a class 5 felony. We asked, Arnold went and asked those individuals who passed this bill, well, some of the people who were working with the people who were passing this bill, why did that happen? Why is it that if somebody carries a big knife, a machete in school, or even a smaller knife, it's a class 5 felony, but if they carry an AR-15, it is a misdemeanor. Well, apparently, this has to do with, believe it or not, the rules in the legislature about the title of bills. You'll see the title of this bill is Prohibited Carrying of Firearms in Sensitive Spaces. Only things that relate to the title can be included in the bill. This said firearms. Well, because the deadly weapon provision did not include firearms, they couldn't address the deadly weapon provision. So they would have reduced that to a misdemeanor as well had they had the chance. Expect next legislative cycle there to be a bill that will reduce the deadly weapons subsection to also be an M1. In the meantime, you have a pretty significant divergence in this statute in the level of this crime. There are other parts to this, so it amends the election offenses that relate to open carrying of a firearm in a polling location or a drop box or a count facility. It's important, we have elections coming up. Those elections offenses now prohibit conduct that include all firearms, whether they're openly carried or concealed. There was an offense aggravator for second subsequent violations within 5 years of someone carrying a firearm into a general assembly. That's gone. And there's this provision here where it removes the ability to charge violations, multiple violations of unlawful possession of a weapon. There's different versions of that. If the person's already charged with one of those election code offenses, unlawful carrying of a firearm in a government building, or unlawful carrying of a weapon at education grounds. Basically, you can't double up these kinds of charges. You can't charge multiple violations of the same thing.
As Brett said, we've got elections coming up, and clearly candidates themselves are interested in what's happening to them. And the first bill we'll talk about, or I think the only bill we'll talk about in this section, is House Bill 241147, Candidate Election Deepfake Disclosures. So what is a deepfake? The bill defines that, makes it pretty clear to say an image, video, audio, or multimedia AI-generated content that falsely appears to be authentic or truthful, and which features a deception of an individual appearing to say or do something that individual did not say or do. Now, who would engage in conduct like that? Not a politician, of course, but some have done that. And there is media out there suggesting that maybe a certain presidential candidate said something when in fact they didn't, and there's an image, and there's a voiceover, and what have you. This AI-generated deepfake is just really expanding exponentially. This bill only applies to candidates who are running for office, but clearly the context could eventually happen to individuals out there in society. So the bill is going to regulate the use of deepfakes for election candidates. And if, in fact, an entity or an individual is going to put out one of those things, they are required, they're not prevented from doing it because there are First Amendment free speech rights, but they have to include a pretty significant disclosure that goes along with the media that's being put out there. So it doesn't completely eliminate deepfakes, but it says if you're going to do that, you also have to put a disclosure, which is pretty lengthy and specific per the statute, that when people see that image or video or recording or hear it, that they also know that this is not really the truth. Now, if a candidate or a candidate for office is the subject of one of these deepfakes, they then have the ability now to bring a civil action for injunctive relief and also seek special or general damages to get recompensated. They also have to prove, though, by clear and convincing evidence that, in fact, that the individual who created the deepfake in the first place did so with malice regarding the falsity or the deceptiveness of the actual communication. Question was raised in a prior venue that, okay, if this is a civil penalty, is there, in fact, any criminal penalty affiliated with it? There is no exception to criminal liability. So if the creation of the false statement meets the elements of a crime and a person knowingly or recklessly distributes that communication, they in fact can be subject to criminal liability as well. So there is a criminal component if it meets the elements of false statements. We're nearing the last section. Other bills of interest. Got a couple of bills here in this generalized section. The first one is privacy protection of criminal justice records. We've had some bills passed in the last couple of years, one most recently in 2023 that requires the redaction of certain information before it's released. One of those bills involves victims of sex assault or child abuse. if there's a case involving that individual or circumstance, current law requires law enforcement entities and others to redact certain information if there's a request to then obtain that. This law is updating those restrictions to actually allow the victim whose records have been redacted to ask and receive those records unredacted. In case they have to use those records for some purpose, they are allowed to get records that are concerning themselves and get that without any particular redaction. The victim or witness themselves or a legal representative or their designee would be able to get those records. There's also another category of individuals who are now also going to be allowed to get unredacted information. They're there on the screen, they're in the book, but they're basically attorneys of record, individuals who are going to have a reason to get that unredacted information, pretty significant list there. The 2023 law that passed with respect to the availability of the records was not quite clear as to on or after what date this law was going to apply. The 2023 law wasn't very clear. So this 2024 update is making it clear that offenses or incidents that happened on or after January 21 is the date that the 2023 law applies to. So for your offices, if in fact you have one of these agencies or representatives asking for those records, you are, again, allowed to release that information unredacted. Excited delirium is a term that law enforcement has used in some parts of the country. They continue to use to describe the behavior of an individual upon whom they may come in contact with, but they may be suffering some kind of medical episode or distress. Oftentimes, this term excited delirium has been used within the law enforcement community to describe that behavior, but it's not a medically substantiated term. There's a lot of debate about what excited delirium is, and the term includes these other categories: delirium syndrome, hyperactive delirium, agitated delirium, exhaustive mania, a category of behavior that really doesn't have a support, I think, within the medical community. So some segment of the legislature said, listen, if we don't want this grab bag term that is not very well defined to be used as a basis to say that law enforcement came in contact with an individual and engaged them and used force, for example, that is inappropriate. So the legislature said, listen, we don't want this term being used in police reports. We don't want this term being used by first responders and as a basis to allow them to engage in contact and say, this is why we did what we did. So it specifically says in training courses, they are not allowed to use the term. Now, if you restrict the use of a term, you have to educate people about the restriction on the use of the term. So in the first versions of this bill, it said you couldn't even mention the term excited delirium. And so if you're going to prevent the use of a term, you have to talk about it and let people know. And so there was a lot of debate in the hearings about, can we even use the term at all? And the first versions of this bill said no. So if you can't talk about it, how can you address it? But with respect to peace officers and first responders, they can't use the term. With respect to teaching emergency medical service personnel, they can use it in a training program, but only for talking about the history of the term. So again, it's an interesting bill that says we're going to prevent a word from being used out of conversation. And then also for coroners and medical examiners, excited delirium can no longer be used as a cause of death on a death certificate. It is going to, the intent of 1103 is to excise this term out of the use with respect to criminal justice and coroners' activities. House Bill 1133 is a follow-on bill to a significant piece of legislation last year, which was the Clean Slate Bill, or rather a bill that passed 2 years ago that allows a pretty extensive sealing and expungement of criminal history records of individuals. Clean slate is that philosophy that believes people should really have second chances and that their criminal history should not be an impediment to what is often called collateral consequences for getting a job, getting education, getting housing. Again, Clean Slate says we're going to allow records to be sealed, and that process is going on right now. Hundreds of thousands of cases are being automatically sealed. 1133 adds some additional opportunities to that Clean Slate legislation to allow an individual to also have their record automatically sealed if it's a case of mistaken identity. the law right now puts the obligation on a law enforcement entity to seek a petition if they arrested somebody for mistaken identity. But if that doesn't happen, the individual now can go in and seek the petition themselves. If they were the recipient of a deferred judgment, they were acquitted, the case was dismissed. Even in VRA cases, those records can now be sealed as well. Again, if it doesn't happen automatically, an individual can go in and get those records sealed. Marijuana is now legalized clearly for a long time in Colorado. There may be some other offenses that might have been illegal in the past, but are now legal. This bill is now going to retroactively allow individuals to go back and seal those cases if they were convicted of an offense 10 or 15 years ago, but now society says that conduct is now legal. Individuals can go back and have that prior conviction sealed. If an individual has multiple records of conviction in the same judicial district, they don't have to file a sealing motion in every single case. They can file the motion in one case. The judicial district then has to combine all those records together and seal them as part of one particular case rather than individual cases by themselves. Defendants who have sealed records and may need to access those records, or their lawyer for some reason needs it, it may be criminal related or it may not, that individual can go to the court and now say, listen, give me my records. They were previously sealed, but I have some kind of legal action where I need myself or my lawyer to get access to those records. The court can provide those to the actual subject of the sealed record. Some of this process requires courts to hold motions hearings or hearings on the petition to seal. The law is now saying all of those can be done virtually. They don't have to be an in-person hearing. The subject of the sealed record can participate remotely. In the clean slate legislation that had passed a couple of years ago, it was pretty clear that if a record is dismissed due to an incompetency finding, similar to those timelines that Brad talked about earlier in the presentation, those cases that were dismissed due to incompetency were ineligible to be sealed. This is undoing that and now saying if a case is dismissed due to incompetency, all the records related to that case may also now be sealed as well. So it's an expansion of some of the clean slate legislation that passed a couple of years ago.
We are approaching the end here. These three crimes on this statute, or in the three statutes you see here under SB 2411, these now allow proof that the image was either real or simulated, and that the intimate parts are either real or simulated. So that is new, and it is also not a defense if the image or intimate parts are only partially digitally created or altered. So some combination of real or simulated is also now going to be illegal under these three crimes. Under 2435, this is consistent with the vacature provisions we were just talking about. There is now, first of all, this was a bill, I believe this was also a bill that CDAC was pushing this year. Or actually, this was a bill that an elected DA was pushing, and it resulted in some changes. And ultimately, what the attempt was to make human trafficking just a per se crime of violence. So it would mean that you get all the benefits of mandatory sentencing and whatnot on the crime of violence. But the legislature opted to go with instead the version of crime of violence that still requires proof of serious bodily injury or threatened use, possession of deadly weapon. Good luck proving that in a human trafficking case. They're extremely hard cases. And of course, as the testimony was said at the legislature, these victims don't need to be threatened with guns because the nature of human trafficking is such that they just don't need it. It's part of the coercion and control, the oppressive coercion and control in these cases. This also extends, this was a really significant change. Adult human trafficking used to have a much shorter statute of limitations. It is now 20 years. So both for labor and sexual human trafficking, you're going to have many, many, many years. If your victim is not ready to report, is not ready to talk, they have plenty of time. And in some of the individuals, it takes them 20 years to get out of that world, to get out of the coercion and whatnot, and to get their lives in such an order such that they are ready to proceed with the prosecution. So that was a huge change. Of note, human trafficking, labor, or sexual related to children is still no limit. That's because it's a crime against children. Also, there is now an affirmative defense if, in adult charges, if the defendant can establish that they were a victim of human trafficking themselves. This is consistent with the vacatur provisions we just talked about. They also were required previously to get an affirmative defense. When they were able to get the affirmative defense, they were required to show by preponderance of the evidence that they were a victim to get the affirmative defense instruction. Now, that is consistent with all other affirmative defense instructions. They now require only a scintilla of evidence to be able to get that instruction. So if you somehow are able to get a human trafficking case together and may have it be prosecutable and you're in trial, expect, if you're prosecuting someone for human trafficking, expect them to raise the specter that they themselves were in fact a victim of human trafficking. And then they are going to be able to bring on all of the evidence that they were trafficked as a victim, and that will be affirmative defense. Also including, and this is not a crime, but this is really interesting, especially in the investigation of child sexual abuse cases. And really, frankly, anybody who's a parent or has any interest in this, Colorado passed this bill that now requires much more rigor for coaches who are coaches to what are called youth sports organizations. They now are required to go through mandatory reporter training. These youth sports organizations are also encouraged to make coaches, and by the way, it's not just like the coach, it's like assistant coaches and people who act like coaches and people who are traveling with kids who are sort of like coaches. They are now encouraged, these sports organizations are encouraged to create all of these like abuse prevention training programs that include all of these things that are supposed to help prevent abuse and to recognize abuse and to encourage reporting of abuse. They are also required to create prohibited conduct policies. And these conduct policies require coaches to comply with them. It also lists prohibited conduct by other individuals. You might be surprised to learn parents, spectators, coaches, the athletes themselves. There's a mandatory reporting policy for adults who have knowledge of an act of prohibited conduct. That has to be included in prohibited conduct policies. There has to be a system for reporting violations of a prohibited conduct policy and a process for investigations, due process requirements, sanctions for violations. These YSOs are really required to do a whole heck of a lot more now in making sure that abuse is prevented, it's caught, it's reported, and something is done about it. Interestingly, the youth sports organization coaches, they are required to conduct a criminal history check before the coach starts. Felony child abuse and felony unlawful sexual behavior will disqualify coaches from being coaches now. Misdemeanor conduct, I suppose the organization could voluntarily decide that as someone who's convicted of misdemeanor child abuse or misdemeanor unlawful sexual contact perhaps, that they can't be coaches in their organization, but it is not required under the statute. Other thing, in this last bullet point here, somebody commented, I think it was Arnold, that it may be possible that this last bullet point sort of swallows this whole thing up. There are major exceptions to this. So excludes neighborhood youth organizations. It excludes public and private schools, kindergarten through grade 12. It excludes child care facilities, and it excludes institutes of higher education. So again, this is not a crime. There's no crimes listed here, but this will affect your investigations. And so if you're seeing this kind of stuff happening, if the local child care facility has a soccer team, a youth soccer team, maybe that doesn't count and police can't request the prohibited conduct policies and the mandatory training that these coaches are required to do. And that is all for today. Thank you very much. This is our contact. Thank you very much for your time.